Hi, Manny Fitzsimmons. I'm your Washington REALTORS Legal Hotline Lawyer. This is another episode in our series entitled Buying Tenant-Occupied Property in a Just Cause State. And I'm happy to be joined one more time by my friend Kaitlyn Jackson. She's a lawyer, landlord, tenant lawyer with Williams Kastner in Seattle.
Correct. I have been practicing landlord-tenant law since 2018. And I do a lot of transactional work for real estate that is occupied by tenants. And so it's my day-to-day.
And so I want, in this episode, Kaitlyn, for you to give us a 3-word answer to this question. Broker calls me or sends me a question on the legal hotline and says, I was just contacted by a seller who wants to sell their property. It's tenant occupied. What do I need to tell the seller about the length of the notice, what the notice should say, how the notice is delivered? What's your 3-word answer?
Call a lawyer.
Atta girl. Why is that so important? Because, and I want you to answer this question from this perspective, because there are a lot of brokers who have been selling real estate for a long time, and they have helped for years. They've helped landlords draft that notice to let the tenant know it's time to find somewhere else to live because the seller's going to sell their property. No broker should do that in today's world. Kaitlyn, why not?
Well, unfortunately for landlord-tenant law in Washington, it has become a statewide just cause state. And on top of that, multiple cities and counties pass their own ordinances, which make providing proper notice very unique for each city, county, and the state. And so there's all these different requirements that a property may be subject to that the drafter needs to know about. And then on top of that, those requirements are changing rapidly all the time. We have about 300 cities in the state of Washington. We've got 35 counties. We've got federal laws that also apply. And all these things are shifting all the time.
So simply put, there is no one-size-fits-all answer to the amount of notice required when a seller wants a landlord, when a seller/landlord wants a tenant to vacate the property prior to sale, right?
Correct.
That answer will necessarily depend on state law, local law,
county.
Mm-hmm. And then on top of that, the notice is only, the amount of notice is only one issue, right?
Right.
There's requirements for what the notice document itself has to say?
Correct. So an example would be in certain cities, anytime a tenancy is being terminated, sometimes that city will have a clause in their local rules that say any notice to terminate have to have this sentence in 14 font in bold, or the notice is invalid. And it doesn't matter if it's a pay or vacate notice or a 90-day notice to terminate to sell or a 120-day notice to do maintenance or repairs, significant maintenance or repairs. If that language is not in that notice, it's invalid and you got to start over if it's not there. So knowing those idiosyncrasies is absolutely mission critical.
Okay, so the length of the notice, what the notice itself says, what about the way that it's delivered? Can that be important?
It can be. I have not seen a whole lot of movement on that front at the local level or the state level. And I would say, unfortunately, there's a state statute, RCW 5912-040, which generally governs any termination notice and how it is served. If there's rental increase notices, however, and this is not really relevant for today, but there are shifts along those lines of how those notices need to be served. But I imagine that the issue of serving notice is just one more thing that could change at the city and local level that is being watched carefully.
Okay. So, Kaitlyn, if you got a call from a potential listing broker who said, my seller needs assistance getting a tenant out, or if the broker has already advised the seller to talk to you and the seller calls you, what might that conversation between you and the seller or the seller and the listing broker look like? Do you have a different conversation depending on where the property is located?
Oh, definitely. So this happens to me relatively routinely, where I will receive an email from a listing broker and their, client say, hey, I've been referred to you. We have a property. This is the address. My client is on this email and they would like to sell it and it's tenant occupied. We'd like to know what we need to do in order to sell it without the tenant being in occupancy when we sell. And the conversation, obviously I will do some, make sure that there's no conflicts and waive conflicts and make sure that's, all taken care of before I move further. But we talk about where's the property located, what type of property it is, because it's different if it's, a multiplex versus if it's a single unit. We'll talk about whether or not there's outstanding habitability issues that the owner knows about, outstanding maintenance issues that the landlord currently knows about. There's a whole list that you go through to ensure that when you're providing that person with guidance, they understand all the different hurdles that they may have to get over, all the different speed bumps which could slow them down. Even at the court level, I have a very different conversation with somebody whose property is located in King County versus if I have a conversation with them and their property is located in Pierce, because the court process alone in King is 7 months just to get a hearing. Whereas in Pierce, it's 3 weeks, maybe 4. So very different.
So I want to follow up on something that you said. You ask about whether or not there are any outstanding repair or habitability issues. Why does that matter when all that the seller wants to do is just terminate the tenancy?
Because if you are a landlord in the state of Washington, if you terminate a tenant's tenancy, or even attempt to, in a certain timeline after they've made a request for a repair, or there is a maintenance issue, or there is a habitability issue, it can be seen as retaliation. And the state is very protective against landlords just deciding to terminate tenancies rather than deal with underlying issues with the property that have affected a tenant.
Okay, so here's what I think I just heard you say. If a listing broker is trying to be helpful, a potential listing broker is trying to be helpful to that seller who wants to sell, and they help the seller deliver a notice of termination, whether it's a quality notice to terminate or even a flawed notice to terminate. If that notice to terminate is delivered and it happens to be within a time frame following the tenant's request for repairs, then that seller, with the assistance of the listing broker, who probably wasn't even licensed to draft that notice in the first place, that seller, with the assistance of the listing broker, may now be liable for retaliation by the tenant.
And it goes a little bit further. I mean, anytime a tenancy is terminated improperly, even if the tenant at the end of the day voluntarily vacates, many local ordinances will actually grant the right to that tenant to turn around and sue retroactively for wrongful eviction and the penalties associated with a wrongful eviction, even if they ultimately left, but because the notice itself was flawed or the reason was flawed, can be extremely financially painful.
Okay, here's what I want to do. I want to wrap this episode because I want to come back in another episode and talk about the difference in types of termination between a seller moving out a tenant and a buyer wanting to give notice to move into the property. But before we leave, something Kaitlyn just said made me think about one concluding thought for you, designated brokers. You should consider with your firm's legal counsel whether or not you should create a firm policy prohibiting your brokers from drafting termination notices for tenancies, prohibiting brokers from assisting sellers to draft termination notices to terminate the residential tenancy so that the property can be listed. Arguably, this is the unauthorized practice of law. And firms, or designated brokers, as you can understand from what Kaitlyn has said, it's an action that, if liability is created by a broker's failure to ask the right questions, to even know the right questions to ask, and then to draft we didn't even talk about if you draft the notice improperly and you get all the way up to the unlawful detainer action, right, 90 days later, but the notice was drafted improperly. What's the impact of that, Kaitlyn?
Well, if the case is dismissed, you got to start all over again.
You're all the way back 90 days earlier.
And like I said, that's not 90 days. I mean, 90 days is the time of the notice. Getting to court is a whole other timeline. And like I said, King County, it'll be 7 months right now. If I even, the 90 days is expired, I served the lawsuit, the timeline to respond has passed, I got to set a hearing. 7 months from now. If I tried to file one today in King County, probably be October before I'd get a hearing date.
So designated brokers, just think about that with your own firm's legal counsel, whether or not you want to create an office policy around this issue. If you have questions on anything we've covered in this episode or anything else, ask me a question by visiting WARealtor.org. Thank you for being a Washington REALTORS member.